Is it time now, though, to declare victory in the fight for voter rights, or does the battle still rage in the form of voter ID laws, gerrymandering, and voter purges? That question is at the heart of a case the Supreme Court will hear next Wednesday. The civil rights movement of the 1960s, including the March from Selma to Montgomery, led to the passage of the Voting Rights Act of 1965. It outlawed discriminatory voting practices like literacy tests, poll taxes, and intimidation. Section 5 of the law requires states and counties with a history of discrimination to get permission from the federal government before changing any voter rules. A total of 9 states are currently subject to Section 5. Certain communities in another 7 states are also covered. In 2006, it was reauthorized for 25 years with overwhelming bipartisan support. But now a constitutional challenge has put this landmark law in the hands of the Roberts Court. Joining us in the War Room to talk about the case is Doug Kendall. Doug is the founder and president of the Constitutional Accountability Center. He comes to us from Washington, D.C. Welcome to the War Room, Doug.
Thanks for having me.
Doug, you know, Shelby County, Alabama, has brought this Supreme Court challenge to the Voting Rights Act. The county says it's been almost 50 years since the act was passed, and we have a black president. Not just a black president, he was reelected. So states like Alabama, they say, shouldn't be singled out. How do you respond to that?
Well, Shelby County, Alabama is about the last place in the world that has standing to make that argument. They've been found in violation of the Voting Rights Act innumerable times. And so, and the basic response is that while things may have gotten better in the South, there is still a significant body of evidence, both developed by Congress in 2006 and then developed over the course of the 2012 election, that voter suppression efforts targeted at minorities and having a disproportionate impact on minorities are alive and well out there in these covered jurisdictions. And so the Voting Rights Act is as vital as ever, and we found that out during the 2012 election.
Yeah, I want to ask you, when you're talking about Shelby County, Alabama, is there a difference between, does it have to be a blanket changing of the Voting Rights Act, or is there a process by which, whether it's Alabama or South Carolina or any other state that is under this, where they can go and they can say, we want to be exempt from this now? Is there a petition process to get out off of this probation?
Absolutely. There's a process called bailout. Which actually the Supreme Court has made even easier to exercise, which allows jurisdictions that are covered under this Section 5 of the Voting Rights Act, which requires jurisdictions just to get pre-clearance from the Justice Department or a court before changing voting rights laws. If you think you're covered under that section inadvertently or inappropriately at this point, if you have no intention whatsoever of discriminating on the basis of race in the ballot, you can bail out of pre-clearance. And if you show that in fact you haven't discriminated against on the basis of race for the last 10 years, those petitions are always granted.
Yeah, so I mean, it's like a parole board in a way, so that they can go before their own little parole board.
It's a way of constantly adjusting the coverage of the Voting Rights Act and making sure there's also a process called bail-in, which if you find a number of violations of the Voting Rights Act, the Voting Rights Act covers every place in the United States with a prohibition against voting discrimination. If you're in a area not covered by this preclearance provision, yet you continuously violate the provisions of the Voting Rights Act, you can actually be bailed in. You can actually be put in and subject to preclearance.
Right.
So you can bail in, you can bail out, and the coverage thus of Section 5, which is this really critical provision which kind of makes you have to show that you're not discriminating rather than it being the other way around. There's ways to make sure that coverage really gets at the worst actors in the system.
And Chief Justice John Roberts, trying to be his own bailout board, has said that things have changed in the South. He said that before, and that blacks now register and vote as much as whites in many southern states. How do you think the court is going to split on this, knowing what you do about the court?
Well, I mean, the first thing I'd say is the voting registration figures and the voting turnout figures just reflect that the Voting Rights Act is working. It doesn't show that it's outdated. In terms of how the court will rule, I think, the court had a case that raised the exact same issues before 4 years ago. The conservative bloc, including Chief Justice Roberts was definitely skeptical about the act and definitely said some things that make you worry about whether they will strike down this key part of this iconic civil rights statute. On the other hand, they had before it the chance to do so 4 years ago, and they punted. They decided not to do that. And I think that gives hope that they could do it again and they could uphold rather than strike down this absolutely iconic and absolutely vital law.
Well, here's hoping that the other team punts once again. That would be a good thing. Doug Kendall of the Constitutional Accountability Center, thank you for enlightening us on this very, very important piece of legislation that will be before